Hey everyone, I'm Denise Howell, and Matt Curtis and Gabby Ziccarelli joined me today on This Week in Law. They're gunning for your video games, folks. Lawmakers are considering whether violent video games should be more actively regulated, and also whether loot crates are gambling and need to be treated as such. We look at Pepe the Frog and copyright considerations around him. VPNs, regulating them, how they are critical to business operation and the tension between those things. And the Fire Festival promoter goes down in flames, takes a plea, and millennials are making up their own language. All this and more on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, Mike Keyes, and Matt Curtis. Episode 416, recorded March 9th, 2018. Pick up the phone. Hello and welcome to This Week in Law. I'm Denise Howell, and you're joining us for our 416th episode today on March 9th. We are so thrilled to have you here. I personally have been listening to Above and Beyond all morning, so I've kind of got this Euro dance club vibe going that I'm hoping that we can just carry through the whole show. And when I got on Skype with Victor, I thought he was singing. So hopefully we'll have a musical show, although we have absolutely no musical stories in the rundown for today. We do have, however, a wonderful panel of folks to join me to discuss interesting issues at the intersection of law and technology. Gabby Ziccarelli is joining us again. Hello, Gabby. It's great to see you.
Hi. Good to see you as well.
Gabby's a lawyer at the law firm Blank Rome in Washington, D.C. She is the former editor-in-chief of the Santa Clara Computer and High-Tech Law Journal. And she is the co-host of her own show called Hustle Over Entitlement, which I just noticed has wrapped up its first season. And this just floored me, Gabby. Number one, that you have finished a season's worth of shows. And number two, that you are doing your shows in seasons. This is brilliant. You get to take breaks.
Yes, that was the plan. Let's take a little bit of a break, give folks time to catch up as well. And we're actually already recording season 2. So get ready, because later this year, there'll be a second dose of inspiration coming your way.
Yeah, tell people about the show if they have not listened.
Sure. So Hustle Over Entitlement tells the stories of trailblazers and risk takers in their respective fields. We hope to focus on folks who have either done a 180 in their career or have actually created their own career with the vision that they had of what they wanted to do. So the hope is, by learning about these individuals who have done outstanding work, so for those who are listening, Denise is actually one of our guests from season 1. You'll get a chance to get inspired and figure out what it is that maybe you want to do with your own career and take that jump and do something exciting. So you can find us on all of the traditional platforms, iTunes, on Google Play, and we are now streaming on Spotify. So I encourage you to take a listen and get inspired.
It's really cool. And thank you for plugging the episode that I was happy to join you and Camille for. I love that your final episode of your first season was I Hustle for Balance, because it's all about taking a break.
We need it. We need it. Right. Exactly. Yes. We're able to recharge and do more if we take that time.
That's great. Also here is Matt Curtis, who is a law student at Notre Dame and my co-host here at This Week in Law and the host of his own Law Pint podcast. Hi, Matt. Great to see you.
Not much hustle on that end recently, unfortunately. We won't make Gabriella's podcast for that. But things are great. We do have a little Fire Festival news, which I'm always a fan of. So the lack of music there is musically going to be available to talk about.
That's true.
But I just think it's great. One quick question, Gabrielle. Do you drop all of the recordings all in one day, sort of like a Netflix style then? Or is it that you just incrementally put them out?
So we put them out weekly. Once we start the season, it'll go through every week. And so, yeah, it's not, it'd be cool if we do a Netflix all at once. But we like to, tease a little bit every week, give folks time to catch up. What I'm learning is that a lot of people are subscribers, but, it takes a time to catch up, especially with holidays and whatnot. So we try to give folks that time.
Cool.
Right. And Gabby, I'm sorry. Actually, Gabby and Matt, I'm so sorry that I did not send you the memo before today's show that everyone was to come in official podcast co-host attire, which means no sleeves. I don't know if you guys saw the Boing Boing story or the ModCloth shirts that are for sale that are the podcast co-host shirts. So I'm wearing my, they are sleeveless. They are all sleeveless. So I'm wearing my sleeveless dress in honor of being an excited and eager podcast co-host. The Boing Boing post was just classic. It said, I prefer to think that the name and description for the podcast co-host sleeveless top in fog, which refers to a gray color, was written by a neural net. And the description itself is, even a late night in the studio deserves your best style effort. Show you agree by sporting this black top. Well, again, they're describing the black one here to record your next episode. Boasting a notched neckline and a deep blue trim down the center, this loose and flowy ModCloth namesake label top makes your outfit just as clever as the insights you share with your digital audience. So if they have pulled me into plugging their company, I guess I'm pleased to do it because I just think this is hysterical.
Denise, did you 10 years ago, did you think there would be a podcasting outfit that would be sold this way?
Never at any time did I think there would be a podcasting out.
It looks really
sort of sad that it's on discount, though. That is a little.
Yeah, well, they have others on the site still for $35. Okay, so I think certain colors sold out.
we gotta order one of these for Mike.
There are prints, there are solids. Yes, don't you think we should all show up one week, Matt, all in our podcasting sleeveless co-host?
Yeah. Look at all those options. Okay, I'm gonna check this out. Thanks for the tip.
Oh, sure.
And we gotta have the bow tie guy back on for that show.
That's right. All right. Enough frivolity. Let's talk about games.
Ooh.
Because nothing says frivolity like a really, really violent video game, right? There are a couple of things going on legally, regulatorily in the video game industry that if you are a gamer or know gamers or care at all about that industry, you want to be paying attention to. The one that most people will be familiar with, I think, is the fact that in the wake of the Parkland shooting, once again, as seems to happen after mass shootings in our country, tragically, there is always inevitably a discussion about violence in video games and the role that violence may play in taking our society to bad places and leading to things like shootings. Importantly, there has never been a study that has successfully scientifically linked video games with actual violent acts. Notwithstanding that, there was these discussions, again, sort of inevitably come up. And I believe it was just yesterday, possibly the day before, Donald Trump held a meeting at the White House with some video game executives and some folks on the other side of that spectrum, representatives of the Parents Television Council, for example, to discuss what we do about the fact that video games are violent, and some people are worried about this and whether lawmakers need to step in. So I've read a bunch of the coverage of this meeting. There are some interesting tidbits we can tease out. It was not filmed or broadcast. So the upshot of the meeting we're getting from interviews with people who were there, who described the president as sort of in information gathering mode, asking lots of questions of the various attendees, getting their perspectives on things. And also that the meeting, I believe, kicked off with a supercut of various clips from various violent video games, which, just as an aside, the gaming site now I'm not sure if I'm saying this right, but I read it regularly when we're looking for information on the gaming industry. Kotaku.com points out that it was an 88-second reel of footage from various games. Actually, The Verge went through and identified each and every one of those games. We've got that in the discussion points for today if you want to see all of the games that were included. But some of them were Wolfenstein and Fallout 4 and Call of Duty. They included the notorious No Russian mission that allowed players to witness or participate in a massacre of civilians at an airport. And then Kotaku goes on to point out, the video is currently hosted on the White House's YouTube page, unlisted, but they were able to find a link. And interestingly enough, for us here at This Week in Law, the clips appear to be ripped from YouTubers' footage of the game, as well as from the gaming outlet Giant Bomb. Now, I'm virtually certain no license was obtained for the use of those clips. So for all of our law professor friends listening, I hope you are incorporating the layers upon layers of potential fair use analysis that we could pour into that particular hypothetical, or it's not a hypothetical, it actually happened. So just bookmark that for your future copyright exams. So this clip was played. It's some very bad stuff happening in video games. One of our commenters on our Facebook This Week in Law page saw this and said that the particular, I think it was the massacre at the airport scene he was referring to. This was Harold Berninghausen there says he remembers that Call of Duty and that it's a really old game. So, they were, I'm not saying the new games are any less violent than the old ones, but they, were trying to pick, as he said, the worst of the worst, it sounds like. And so this discussion took place from the legal standpoint. One really sort of interesting thing to note is there has been litigation and ultimately a Supreme Court decision back in 2011 on one of the key issues that was discussed, which is, should we have criminal laws on the books that prevent people from selling the rated M, extremely violent games to minors? And this case started out, ironically enough, in California. So here we had the president voicing concern, making comments about, should we be treating these things like alcohol and tobacco? And he finds himself lined up, as I said, ironically enough, with the state of California, or some of its lawmakers anyway, who enacted such a law. That led to this Supreme Court decision in 2011, a decision authored for the court by Justice Scalia, which found that no, constitutionally we can't distinguish between things like video games and literature. That you can't stop bookstores from selling Dante's Inferno, for example, to people under the age of 18. And because you can't do that, you also can't stop video game stores from selling these kinds of games. There was a lot more to the decision than that. That was just one of the points that were made. But the upshot is that a First Amendment challenge to that law was successfully launched, and it carried the day 7-2 at the Supreme Court in 2011. Another just sort of side note there is that Hillary Clinton, when she was a senator, is another person who I'm not sure if she authored a bill, but the Washington Post reports that some of her work as a senator centered on perhaps doing age regulation for video games like this, in addition to, of course, the voluntary rating system that's in place. So something to watch if you are a gamer or in the gaming industry, or otherwise just interested in these developments. This discussion took place, and we may see some sort of resurrection of laws like this that would attempt to treat video games like alcohol and tobacco and regulate who can purchase them based on the content of those games. Matt, what do you think about all this?
Yeah, so I think there's just a lot going on here. The first thing is although I doubt that there's like an actual correlation, like to think, on the video game maker side, they're saying that there is no study that has ever scientifically shown that this is correlated. Well, the difficulty of showing that study is just immense, even if it was true, which I don't know if it is or not. But the difficulty of showing that like an activity that someone's taking is leading them to shoot somebody or like have these mass shootings would be like, just because there's like so much that goes in your life, there's so much entertainment, there's so many interactions, there's so many things that go into it. It'd be really difficult to show that. So, but again, I think that like what the Supreme Court said in the 2011 case is ultimately right. These activities come in and, whether it's through a medium of television, a medium of books, a medium of video games, these are free in our society, and ultimately you kind of have to rely on parents to make sure that the things that their kids are getting in the kind of influences are something that they're comfortable with and are something that are nurturing. And so I think that's the right call, because I think that ultimately, a decision from a legislature to say this isn't going to work in any situation and this isn't going to lead to human flourishing in any situation, when you get into speech is always a really difficult call. And politically, the interesting thing is that this just takes heat off of the gun lobby. The question of whether we should have AR-15s or not. It's sort of an easy sidebar to throw in there and say, oh, what about the video games? Which, I take no position either way on those things, but it just seems like an easy out of that conversation to talk about video games.
I'm not quite sure how this works, and I'm certainly not sure how it works in each and every one of the 50 United States. But I know this law was floated in California, and then I think it became law. It must have, if it went to the Supreme Court and then was declared unconstitutional. But so it's not operative and has not been operative for some time, at least in California. Yet if you walk into a GameStop in California and you're underaged and you try and buy a rated M game, I don't think they let you do that. And I'm not sure why. Maybe that's just, a policy, a corporate policy decision, rather than a legal requirement. But I know, as you said, it being up to the parents, Matt, for years, I and my parental colleagues would be implored by our children, this one's not that bad. Here are all the aspects of this game, not just to approve the play of the game in the household, but to actually have to go down and purchase it because it was rated M and it couldn't be sold to them. Maybe there was a window where that law was operative, and GameStop and others were simply following it, and maybe they just never rolled back their policy after that. I don't know. I'd be interested if people know exactly how that works from state to state, because I know I've always been part of the process in deciding whether a rated M game was going to come into our house, and then not just part of the process in making the decision, but having to actually fork over cash over counter to make it happen. Gabby, what do you think about all this?
I agree. I think, if you look at talking about alcohol compared to a video game, there's an expression component. I think back to the many moons ago when we used to buy CDs at Sam Goody, and there was explicit content, right on the cover of one of my favorite rap albums. It's the same concept. We don't want to live in a Fahrenheit 451 society. We have to allow this expression to happen. And, to the earlier point that was made, this takes the attention off other issues that play into the calculus of whether or not these games do have an impact. Mental health, how guns are being sold in different states. And I think the reason that we're focusing on this particular issue with video games is because of the age of the shooters, right? We're talking about shootings happening at schools, and traditionally younger adults are the ones who play video games. So this feels like a deflection. And I think that everyone's making an effort to try to figure out how do we make sense of this. But to Matt's earlier point, there's a lot going into that calculus as to whether these games are really the cause of the issue. And we have to look at the other things at play in order to make a determination.
Yes, excellent point. And I'm sorry I was chuckling at the end there. I glanced at IRC where Chumley has just said, I'd rather them play games than become Raiders fans. So it's all a question of what your family values are, I think. One thing I wonder if it came up or was discussed in this session that happened this week, or it's certainly something that belongs in the discussion. And one of the ways I have been talked into bringing M-rated videos into our video games into our home is the mechanisms that the industry voluntarily puts in, that the game developers voluntarily put in, that say, yes, we have some very violent content in this game, but you can turn it off. You can sort of choose your own adventure, how violent you want the game to be. So, I think that's certainly a welcome feature for parents who are concerned about these kinds of issues, and in one way to address the problematic aspects of it. Like you were saying, Matt, even if the science doesn't bear out, there's one of the people who attended this meeting was interviewed by the Washington Post, and she said something along the lines of, yeah, I know what the science says, but as a parent and a high school teacher, I intuitively feel that there must be some kind of impact. And I think that is the driving force here, is people's just sort of gut reaction that long term, this has to be something that changes how you think about these kinds of activities. The flip side of that, of course, is, if you are a mentally stable individual capable of determining real from not real, this is pure fantasy. There's nothing distinct between doing this even in a very interactive way and reading a book or watching a movie. Query whether science will be able to make a distinction between those kinds of media in the future. I think that the 2011 Supreme Court case definitely leaves some doors open for better, more detailed science to come in and convince a court. I think the court was unconvinced by the science that they were presented with. And it also leaves room for the laws to be more specific. They were concerned that the California law was too vague, and that also that it was inconsistent, that you could have games with adult content that could be legally sold, but not violent content, and why should you distinguish between those two? Any final thoughts, Gabby?
No, I think it's just something to keep an eye out on, especially if you're in this space and you're developing. To Denise, to your point about, a choose your own adventure, there might be a way on the development side to still create a really exciting experience for your end users, but also keeping in mind that legislation in this space might evolve at some point. And, how can you go ahead and turn things on and off without impacting your business? So I think it's worth keeping an eye out on.
Yeah, definitely. Matt?
Yeah, just that, and I have no experience with this, but parenting's tough, and it's a balance in what you allow your kids to do and what you don't allow your kids to do. But ultimately, I think that's where, that's where your morals, that's where your judgment comes from, and we kind of have to rely on parents to make the right call, whatever that is.
Mm-hmm.
Yeah, I would agree. Parenting's tough. Day in and day out, it's tough. All right.
Denise.
Thank you. One other interesting legal development related to video games, if you are a gamer, and no gamers, you may be familiar with the concept of a loot box, which is something that you spend actual real world money on in your game, and then it's a mystery what's going to pop out of there. Something is, you're definitely, you're buying something. I don't believe there are any games out there. Who knows? I mean, I could be wrong, but it seems like the game developers would know that if they're charging people for something and they presented an empty loot box, that could be problematic. So you're definitely getting something out of it, but you could get some really great goodies or helpful items in the game, or you could get some more sort of generic bland stuff. So there's an aspect of gambling to purchasing these loot boxes. You may be getting something great, you may be getting something not so great, but you're getting something. In Hawaii, there are 2 bills pending that are focusing in on that gambling aspect of loot boxes. And this is not just unique to Hawaii. There's some similar lawmaking impetus going on in the state of, I believe it's Indiana and Washington State. But specifically in Hawaii, we have actual laws that are pending and may be enacted. One of them would prohibit, and goodness knows how they're going to implement this, they would prohibit retailers from selling games that include a system of further purchasing a randomized reward or rewards to anyone under 21. So they're concerned about that gambling aspect and how it could be harmful to those under 21. The lawmakers have said specifically, and this is in the proposed legislation, unlike traditional card games or other games of chance, the ubiquitous reach of video games, which require active, lengthy participation and exposure to the psychological manipulation techniques of exploitive loot boxes and gambling-like mechanisms, presents potentially harmful risks to the financial well-being and mental health of individuals, and especially of vulnerable youth and young adults. So again, we're trying to keep dangerous things away from young people in this one part of this one bill. And then there's another bill that is probably a little less controversial, probably a little easier to implement, that would require a prominent, easily legible, bright red label to appear on games with loot boxes or on their online retail pages, warning of in-game purchases and gambling-like mechanisms which might be harmful or addictive. And then finally, they're also concerned that the odds of winning be disclosed. And again, that one strikes me, winning what exactly? Is the axe more valuable than the frog or whatever it might be?
Absolutely.
Always. Yes. You think the axe is more valuable than the frog? I don't know. It could be one.
Is it a magical
kick-ass frog?
Could be a magical axe too.
It could be, or just a really wimpy axe. Anyway, yeah. So this is all going on in Hawaii, and if you're a gamer, the thought of not being able to buy your $5 loot box or whatever, unless you're a certain age or unless the odds have been disclosed to you, might be something you're concerned about. Matt, what do you think?
I think it's all illegal already. So you look at RICO, you look at the 2006 the Wire Act and the 2006 Internet Gambling Act, and they define gambling as the risking of something of value for an uncertain event. So if you're paying for the loot and then it's an uncertain event, it's already gambling under the law. There's private right of actions under RICO that you can bring under this. And it seems like any AUSA could bring a criminal RICO charge against the operators of these games. So I guess I don't know why, if it's that big of a deal. The other thing is that the states, they're protecting their interests. They offer, they sell lotto tickets. So I'm not very sympathetic to them creating laws that protect their own business, which is clearly already bad for people. So I think the states it's a hard line for any time that they get involved in gambling and they. So that's but yeah, I think under the 2006 Act and under the RICO and the Wire Act that this is already illegal.
Shh! Don't tell the current administration. How
the
tax
current
laws.
Administration the current administration loves gambling. That's
Right.
how they want. Like, I mean, he runs casinos. Not very well, but he runs them.
Al Capone was gotten on tax laws, right? So maybe this is how the current administration comes after the video game industry. We're getting you on RICO. No more gaming whatsoever. Gabby, what do you think?
The states are going to have to be really careful with how they draft these. If they have a certain plan in mind. I was reading some of the docs that we had sent around, and one of the pieces of language said that this particular legislation was aimed at predatory mechanisms designed to exploit human psychology to compel players to keep spending money in the way casino games do. And when I read that, I don't hear reference to uncertainty. My thought is, does that include coins to extend my life on a game? Where do we draw the line of where we might be crossing over into the uncertainty category? If I'm being promised if I spend $5 and can live a little longer on level 5, where does that fall? And so I think it's going to be an interesting drafting exercise to see not only what you can capture to be truly illegal, but then how people design around it. To say, okay, that's a nice law, but I'm doing this now. So they're still exploiting this human weakness that they talk about to get people to engage and to pay money to monetize their app, but they may just be right outside the law as drafted.
Yeah, excellent point. All right, I think we've got our first MCLE passphrase for this episode of This Week in Law. It's going to be, don't forget RICO. We put these phrases into the show in case you are a lawyer or other professional who likes to watch or listen to our show for professional credit in your field. If you are a lawyer, head on over to wiki.twit.tv, find our This Week in Law page there. I should put the caveat, if you are a lawyer in the United States, we have a guide for you to whether your state might allow you to submit an application to get credit for watching or listening to the show, and some guidance about how you might go about doing that. We'll put another phrase into the show before the end. So if you're in a jurisdiction where you have to show that you watched or listened, this is how we help you out with that. Let's move on now, and you'll see why I had frogs on the brain, frogs versus axes, to a copyright question. This is a really fascinating dispute that has been brewing for some time now, several months now. There is a gentleman named Matt Furie, F-U-R-I-E, who created the Pepe the Frog cartoon character. Pepe the Frog may not mean anything at all to you. I was not familiar with Pepe before reading about the disputes that Mr. Furie has had. But apparently, somehow, Pepe, his cartoon character, through no impetus of his own, the creator's own, has acquired this secondary iconic meaning and is some sort of symbol politically to those on the far right, and pops up in that context from time to time, much to the creator's dismay. So this is not the first instance where the copyright holder has been trying to make sure that Pepe is not used in this way. There's a hysterical photo in one of these Ars Technica stories that have been covering this, of a gentleman holding a poster. Again, now I don't know if he's going to get sued for copyright. He's at a protest or something at a rally, and he's got a picture of Pepe that says "Green Lives Matter." So poor Pepe has taken on a life of his own. There we go. Thank you, Victor. And most currently now, the copyright holder is suing InfoWars because InfoWars is selling a poster with the MAGA "Make America Great Again" caption and various figures on it, including Pepe, who is the only cartoon character that I can recognize in the bunch. So he's suing, saying that use of Pepe in this way infringes his copyright. And so an interesting, the lawsuit's just been filed. We don't know all the arguments that are going to be asserted and how things are going to shake out. But interestingly enough, what the InfoWars folks have come back and said is that, well, a couple of things. First of all, that they didn't create the poster. They're simply selling the poster of somebody who did create the poster. And that to the extent they have any sort of liability for doing that, that it is some sort of fair use, that this is transformative using Pepe in this way because of this secondary meaning that he seems to have acquired, this political context that somehow is associated with Pepe the Frog. So we will see all this play out in this lawsuit. This is not the first time that this has been pondered. I guess back in the election is when the author originally started trying to assert copyrights in Pepe. So it'll be interesting to see if this fair use argument pans out. Also, the term First Amendment tends to get bandied about to free speech. Now, again, this is a private rights holder suing, so I'm not sure exactly how we get the First Amendment involved here, but I'm just chalking that up to the InfoWars side, not quite understanding how that all works. But again, we'll see in the lawsuit how it plays out. Matt, do you have any thoughts?
Yeah, just in terms of the First Amendment thing, Justice Ginsburg uses the First Amendment speech in her analysis of fair use a lot. So although I think they're wrong on a lot of things, that does have like a legitimate basis. The one where they say that, someone else made the frog poster and they're just selling it. Well, that doesn't make any sense because copyright also stops you from selling or offering for sale. So you'd have to get a license for that as well. In terms of the actual fair use analysis, if you go back to the basis of what the transformative test was, it was saying that basically the framework was that you've got to be able to comment on someone's work, and therefore a parody is transformative because it otherwise you couldn't talk about someone's work, and therefore you couldn't like comment, say that it's good or bad or joke about it or anything like that, because they could stop you from saying anything bad about that work, which logically makes sense. In this argument, it kind of falls outside of that cone of analysis that that they want to use this to talk about something else. They're not commenting on Pepe the Frog or anything like that. They're whatever their message is, and I'm not too familiar with Pepe the Frog, either context, but they're not commenting on Pepe. They're commenting on racism or whatever they're talking about. It's not about Pepe. So under that original understanding of the fair use, it would seem to fall outside of it. But you never really know where the court's going to go here. I don't have a good enough grasp on how they go case by case.
Yeah, there are a couple of points that we're likely to see come up in this lawsuit. One thing that has been asserted in connection with other uses of Pepe is that Pepe is not terribly distinctive as a character, that he's called a crudely drawn frog, so such that, really sort of anybody could have drawn a frog and you could call it Pepe. I don't know that I buy into that. Pepe seems to be pretty identifiable as this particular comic frog. So that's something that we'll have to see play out. And then the other thing that Mitch Stoltz from EFF has said is on the transformation point that you raise, Matt. He thinks that it's sufficient for that prong of fair use, that he has told Ars Technica in the past they're using it for the symbolism it is acquired, and that would be transformative under the fair use analysis. Joe Mullen, writing at Ars Technica, has a good analysis that I'm just going to read to you. He says, my own take on Pepe is, and I'm on perilous turf here disagreeing with the EFF lawyer, if it somehow did come down to a real full-scale court case, Fury would likely succeed. Courts often see copyright's role as defending the rights of the little guy, and Fury's story is compelling. His frustration with seeing his creation used by racists is real, and the fact that he endorsed other non-racist uses in the past doesn't diminish his case. The fact that the alt-right users call the frog Pepe and appear to have closely traced the frog's visage contribute to Fury's case. When Fury tells his creation story, shows his early comics, and describes how they were distributed on sites like 4chan, that's going to further bolster his case. The alt-right users could have created a meme of a generic chill frog dude, but they didn't. They picked Pepe. And I think I agree with all of that. What do you think, Gabby?
Yeah, I agree with that. If you're going to call out secondary meaning, they should have renamed this, new reincarnation of Pepe. They still called him Pepe. And if you look at the fair use factors, just alone on this particular poster, essentially they've changed the color. Everything is in like a red and black tone. And it's a collage of a bunch of drawings of people's faces. And it looks like Donald Trump is in the background. So from a pure transformative perspective, I'm not seeing how that's going to hold up in court. Additionally, for example, if they had taken all of the faces of folks from the far right in like pointillism to create Pepe, that would be very creative and may have been truly transformative, but I'm not seeing it here in this particular poster. When you think of the nature of the copyrighted work, so the other prong in the fair use analysis, like you said, it's a pretty arbitrary drawing of Pepe, but it's become so noticeable and it's kind of has this awkward look about it, right? It's kind of this like etched, kind of colored in look from the original meme. So, that could go either way on that prong. And like, Matt mentioned, the court swings back and forth when it comes to a fair use analysis. It's very difficult to predict where they're going to come out. To the next prong, when it comes to, the amount and what was used of the actual original copyrighted work, this is Pepe in his entirety. We see Pepe's entire face. There's no chopping and remixing, if you will. And the question I have, and I think will be an interesting part of any kind of decision that may come out of this, what is the potential market for Pepe? And then additionally for memes across the board. In this particular lawsuit, we have really good examples of how Pepe was licensed. We see, for different, I think there was like a stuffed animal. But for the traditional meme, what is that market? How broad is that scope? That'll be something that'll be interesting to evaluate. And hey, it may inspire other folks who have created memes to enforce their rights if they're going to go ahead and register a copyright for it.
Right. It seems like the argument could be made that as far as the market for the original work goes, that it's actually the symbolism that it has acquired that the rights holder wishes it hadn't, that is created a market around that symbolism rather than a market that originally existed around the comic. Right. So that would be an interesting part of the fair use analysis. And we also should point out that, as I said, Pepe is the only cartoon character I recognize in there. The rest of them seem to be real people. And to the extent you were a real person who found your image used in this way and you objected to it, and it was being used commercially, you would have a right of publicity argument you could assert rather than any sort of copyright in your image. You do have the right to control your name, image, and likeness in most states when it's used for commercial purposes. So just spinning that out. If you see anybody in there who doesn't want to be in there, you might want to let them know that. Any final thoughts, Matt?
Fortunately, I don't have any of their contact information. I think that, it depends on what circuit it's going to be in. And it really depends on, how the judges, I would guess, they would come out saying that there is a copyright and that it has to stop them. Again, though, this isn't, they have to sue everyone who's publishing this on every meme to really get it to stop it. So I don't think that there's actually an effective way to enforce this copyright, even though they might win this one case. When like a movement picks up something like this, it's very, very hard to stop. But I do love the line, they should have drawn a chill frog dude. And I just think that's wonderful. I totally agree.
Yep. We should all be drawing chill frog dudes, I think. Okay, let us move on to an issue related to privacy. Josephine Wolf at Slate has a really interesting piece called in the future tense column there, which is always a fascinating column. It's called "The Internet Censor's Dilemma," and it's about what's going on with VPNs. The sub headline is the more countries try to restrict virtual private networks, the more people use them, and that's sort of the crux of her story. Is talking about various restrictive regimes around the world and what they're doing to take steps with both technology companies and steps on their own legally to prevent the use of VPNs in their countries. She calls out the example of the United Arab Emirates, where for example, it's illegal to use a VPN to commit a crime or prevent the discovery of a crime. So they have an actual law on the book about that. And the other really interesting thing that she pulls out and says this is what's making the climate shift a bit is the fact that in response to the government of China's request, and I presume in order to be able to continue doing business, and we know that Apple does a ton of various kinds of business in China, Apple has agreed to block access to various VPN apps in the mobile app stores that are available through Apple there in China. So there is this battle going on for where VPNs are available, who can use them, what the ramifications of using them are. And it's all made very interesting by the fact that, of course, corporate business internationally doesn't function without VPNs. Mm-hmm. And countries are going to have to maneuver around that reality as well. So just wanted to bring that up and bring this article to folks' attention. It's a good read. I recommend it. Gabby, any thoughts?
To your corporate point, and especially in the legal world, there needs to be a degree of security, especially when you're dealing with client data. And a lot of times you have folks in different industries who are traveling abroad, who are visiting a client, and are handling data that needs to be properly protected. So, this is going to be problematic. We're a very global economy, and there needs to be a way for people to access that information that they need to in a secure way. Additionally, just from, a purely business perspective, I think about one of the items referenced in the article talks about, being able to access Netflix, for example, abroad. And so when someone does that, there could be an issue where, let's say, I am a movie producer. I've negotiated an exclusivity in a particular territory, and perhaps there's an alternative that, there's a royalty scheme. So you're kind of messing with business when you're allowing, someone through a VPN to access perhaps one title over another in that way. So I think it raises some interesting legal questions, and I think it has potential impact on the entertainment industry as well, because territoriality is a big deal, especially when it comes to places like some of the Asian countries that we're talking about.
Right. It's a challenging time, I would think, to be a VPN in the business of operating a VPN, right? Because you've got various governments who don't want you concealing their citizens' activities. And you've got various governments being lobbied by the entertainment industry who want to be able to enforce those kinds of geo-blocking restrictions that you're mentioning, Gabby. Right, so right. You're getting it from both sides. And then when somebody like Apple comes along and says, yeah, we're going to cooperate with China and make it impossible for your company to be offering services there, that must be a sobering development. Matt?
Yeah, so in terms of international politics of all of this, I agree that it's very difficult for a company to do that. But we've got to remember that the Computer Fraud and Abuse Act does a lot of that work here, or at least potentially could if it was enforced in its most extreme way. So, for instance, if I went on the Wall Street Journal through my, without a VPN and had 3 clicks that it showed up on my cookies in my browser, and I opened up my VPN so I could get more access to it, I'm theoretically or actually accessing their computer models without their authorization. So, there's laws in the United States that, if applied to their maximum extent, already make it illegal a lot of times the way that VPNs are actually used. So, shame on other countries for doing things like that. But we also have laws in our books that could be enforced that way.
Right. That's a really good connection to draw, I think, Matt. So explain that for someone who doesn't understand how the Computer Fraud and Abuse Act works. If you're circumventing someone's security that they've put in place to restrict access to certain parties, you think a VPN could fall into that category?
Yeah, I think that even opening up like a what's it in your browser where it like hides your history, like an incognito window. So if you do that to open up, we'll say I've never done it before, but to open up a like an extra journal article that you haven't paid for, then you're getting around their protocols and you're accessing their content without paying for it. And that is beyond their terms of service. They have clearly set like methodologies and protocols to not allow you to do that. And you're accessing their computers, and therefore you fall under the Computer Fraud and Abuse Act. And so the way that it typically, so it works in different situations, and there's a circuit split, which I'm not quite recalling the delineation on it. But when you access someone else's computer without their authorization, this was originally put in place for hackers back in the 1980s in some sort. That's how old this law is. That if you access their computer network without their authorization, you fall under this felony count, federal felony count.
Wow. So just like we're going to tell you about RICO, I think we better do that about the Computer Fraud and Abuse Act too.
Sorry.
Because yes, that's one that can definitely has more teeth in it than it is necessarily always used for. So that's an excellent point, Matt. What else did I want to raise about VPNs? Oh, that there is a great piece over, just got published on March 4th at Torrent Freak. It is not a guide or an endorsement of any particular VPN or VPNs, but what they did was go to dozens of VPN providers, and they asked them a bunch of questions. I guess this isn't the first year they've done this, but it's the first time I've seen it. 12 different questions. I'll read them to you because they are important. And if you are going to use a VPN, you would want to know the answer to these questions. And then if folks didn't answer, then they didn't make this list. Obviously, they're only providing you with information from the companies that were willing to be transparent about these things, which hopefully, is somewhat self-selecting for making this list as you go through it, a list of companies you might want to consider using as your VPN, because based on their answers and based in part on the fact they were willing to answer. So here are the questions that were asked. Do you keep any logs which would allow you to match an IP address and a timestamp to a user of your service? If so, exactly what information do you hold and for how long? What is the name under which your company is incorporated and under which jurisdiction does your company operate? Important points. What tools are used to monitor and mitigate abuse of your service, including limits of concurrent connections if these are enforced? I love this one. Do you use any external email providers, e.g. Google Apps, analytics or support tools, e.g. Live Support or Zendesk, that hold information provided by users? So very important question to ask, because if you're going to use a VPN for privacy and yet your information is being held in say, email accounts that the company is using and can be subpoenaed that way, there goes your privacy. In the event you receive a DMCA takedown notice or a non-US equivalent, how are these handled? What steps are taken when a court orders your company to identify an active or past user of your service? How would your company respond to a court order that requires you to log activity going forward? Has any of this ever happened? Is BitTorrent and or other file sharing traffic allowed on all servers? If not, why? Which payment system providers do you use? Do you take any measures to ensure that payment details can't be linked to account usage or IP assignments? What is the most secure VPN connection and encryption algorithm you would recommend to your users? Do you provide tools such as kill switches if a connection drops and DNS leak protection? Do you have physical control over your VPN servers and network, or are they outsourced and hosted by a third party? If so, which ones? Do you use your own DNS servers? If not, which servers do you use? And critically, for the case that was just argued before the Supreme Court involving Microsoft servers in Ireland, what countries are your servers physically located in? Do you offer virtual locations? So this is a huge list of VPNs that have answered all of those questions over there at Torrent Freak. And Torrent Freak goes on to say, we're going to provide their answers in full. We've gone ahead and given as much room as necessary to give you all that information. So incredible resource here. And bravo to them for taking the initiative on this. Any thoughts, Gabby?
No, I think I really love that Torrent Freak guide. I think it's important. The more information you have, the more educated of a decision you can make. So great job, Torrent Freak.
Yes. Yay, Torrent Freak. And I think we have our second MCLE passphrase for the show, which is going to be, don't forget the CFAA, courtesy of Matt. Matt, any further thoughts on VPNs or the Torrent Freak list?
No, I think there's no good way to regulate them, and there's no good way to do business without them. So I think these problems are going to continue.
Yes, indeed. All right, we promised you the Fire Festival. Let's catch fire. Billy McFarland was the promoter of the Fire Festival. And do we need a refresher as to what the Fire Festival was? It was or would have been a musical event in the Bahamas, billed as the, quote, cultural experience of the decade. We have talked about it on the show before in the context of the social web because of all of the various Instagram and other format influencers who were enlisted and paid to lend their influence to promoting the show. The show didn't actually happen. Many people paid a bunch of money. Investors paid a bunch of money to try and make the thing happen. But in fact, it was never put together in the way that it needed to be. And people showed up, and not only did they not get a music festival, they got sleeping on beaches in tents and cold cheese sandwiches, among other things. So, in fact, but the poor saps that actually went to the thing, they probably, were physically in danger, not only just not provided with a concert. So Billy McFarland was the promoter of this event and was actually, in addition to having been hit with various civil lawsuits, apparently criminal charges were filed. And just this week, Billy McFarland pled guilty to wire fraud charges. He agreed to serve up to a decade in prison for lying to the investors who gave him $26 million, which he lost. So, Gabby, what do you think about 8 to 10 years in jail is the potential sentence he'll get for pleading guilty to these federal wire fraud charges? Does that strike you as appropriate?
I mean, I will preface this as I'm not a criminal prosecutor, but it seems that this general Fire Festival had a lot of issues baked into it. Also a great potential, example that you could put on a law school exam. Everything from, and I wish I had looked at this, the terms of service on the website for Fire Festival to goodness knows what kind of agreements he had with those investors and what kind of inducement into business he had with them. It sounds like it's probably a good starting point. With $26 million are involved. And my understanding is there's a number of lawsuits that are now pending against him by those folks who did purchase tickets to attend the Fire Festival. I think this is a great example on not only the power of the internet, but the illusion of the internet, that, by throwing up some popular names, and making marketing look legit, if you will, you can really convince people of anything. And I think this is obviously a very extreme example, but this happens all the time with, folks who buy Instagram ads who are selling, trendy clothing or something or other only for people to discover, oh, this was actually all a farce. I just spent $100 and got a dress that looks like a bag. This isn't what was advertised. And so in this internet age, you have to be a discerning consumer. It's very easy to be duped.
Yeah, it sure is. As part of his plea, he also admitted to raising money for the festival by giving at least one ticket vendor false information about the company's financial condition in order to induce the vendor to pay $2 million for a block of advance tickets. Matt, does the fact that what he pled guilty to is wire fraud, is that significant at all? Matt? Did we lose Matt? All right, we'll try and get Matt back. Wire fraud is one of those things like RICO and the CFAA that is lurking in the background, and it might be in the forefront of your mind as you're carrying out business, whether it's nefarious or not. If you wind up using the mechanisms described in the wire fraud statute to transact your business, if you are doing bad things, then it can come back to bite you. And it seems that that is what has happened with Mr. McFarland here. Anything else you want to talk about with respect to social media influencers, social media abusers, or the Fire Festival, Gabby?
I think to your question earlier about whether or not, whether wire fraud is significant, I just think about the cost and money it would have taken to really go through all of these details. I mean, to plead guilty was probably easier and probably less financially burdensome for him. To go through and say that you fraudulently had this scheme to intentionally deprive people of their money. My understanding, and again, this is my amateur understanding of the Fire Festival facts, but he thought he was going to be able to do it, and things started to devolve. And so at some point, I think that mentality switched. I'm going to just keep rolling with this. And that would probably be sufficient to satisfy the mens rea of going in and fraudulently scheming to deprive folks of their money. But it would have been quite an interesting case to watch play out had he not just gone ahead and pled guilty. But I think, keep being mindful of that. Again, as a consumer, things are being presented to you. And with the right graphic designer, you too will believe that you're going to the coolest, most exclusive party. So be discerning, do your research. And good old Better Business Bureau, really helpful in those other instances with social media folks that are, influencers, and they are telling you they got this beautiful bathing suit or this great hat somewhere. Be a discerning person and go ahead and Google what you might be buying before you throw your money in and give someone your credit card information.
Yeah, I mean, you raised a really good point. I think for a lot of people, the sort of trappings of legitimacy are what they look for. This has got to be a real thing, because otherwise I wouldn't be seeing this caliber of imagery or this caliber of people involved endorsing it, et cetera, et cetera. And those trappings just aren't enough to really trust anymore, are they?
No, not at all.
Yeah. All right. There was something I thought you and I, and hopefully Matt, if he gets back with us. Oh, you're back. Yay. Hey, sorry, we lost you for the Fire Festival, so we don't want to leave that subject without canvassing your views.
I think it was appropriate. I was as president as the real value of the Fire Festival. So that may have been the way to go.
Yes. So I had asked a question to you before I realized you were gone about wire fraud and whether you thought it was significant that that's what he pled guilty to, and sort of equated it to both RICO and the CFAA as something that lurks in the background that people aren't thinking about. But if you're using the mechanisms described in the Wire Fraud Act to conduct your business, that it's certainly a federal crime where one might not have existed before. Any other thoughts about that?
Yeah, wire fraud is just so broad, and it's really like, when does the AUSA want to prosecute under that statute? Because all of our communication happens over a wire, and so anytime you do something fraudulently over a wire, like, you could theoretically be brought that cause of action. And probably more importantly, it's a private right of action. I can't remember if there's increased damages because of that, but I have to assume that they are. And so it's something that, like, you kind of always need to be aware of. And so just another good reminder of not to commit fraud. I'm not sure how helpful that reminder is, but it does make it a federal cause of action.
Yeah. And I think as far as you say, a reminder not to commit fraud, I'm sure that the prosecutors here realized they had a very public dispute on their hands here, and wanted to make an example of Billy McFarland, and the fact that we're seeing him plead guilty to something that could land him 8 to 10 years in prison is not too surprising, given the opportunity here to make an example of how this kind of activity isn't going to fly. So I think that could be the end. Although there are this, as you pointed out, Gabby, there are civil lawsuits that are still pending. So I don't know what they'll be able to accomplish with Billy McFarland in prison, but we may see those play out as well. Gabby, so remind our listeners, if they have listened to you on the show before, they will probably remember that you helped edit the, what is, I would say, the iconic scholarly article on emoji law. And remind folks what that publication is called, and so how they can refer to it when they need to.
Sure. I'm going to make sure to get the official title. This is in conjunction with Eric Goldman. He has done this amazing job of putting together essentially where we are right now with the law of emojis. And to those listening, believe it or not, we do have some guidance on the law of emojis. And so it's a very simple name. You can find it on SSRN. The most up-to-date version was put up recently. It's called Surveying the Law of Emojis by Eric Goldman. And also encourage you to check out Eric's blog. He and I have co-authored some pieces on some of the developments in this space. And the great thing about emoji law is there's a lot of ambiguity. As you can imagine, folks interpret emojis very differently. When they're used as evidence, things get fun. And so definitely encourage you to take a look at those resources to learn a little bit more about where we may be headed with emoji evidence.
So there was a Twitter moment that popped up this week that made me think of you. It's captioned, "How Millennials Are Creating Their Own Language." Copy editor Diana Hoke shared an online post about the way millennials use grammar to encode meanings that older people are less familiar with. And I thought this played right into the emoji law analysis. That it's not just, how and whether you're using emojis, but whether you're putting things in all caps or using your caps selectively or including punctuation or using a 2 or 3 dot ellipsis, that all of that has come to connote separate meanings. Did you, anything you want to add to this, or maybe add to the corpus of analysis on emoji law?
I have to tell you, technically I'm a millennial by the definition, but this was all new to me. So I do believe there are subcategories within generations. And that just goes to show you that if you were dealing with, say, someone's text messages who was in the, 18 to 25 range, you may need a specialist who's going to help you decode what that means. I mean, to add to the confusion of punctuation in text messages, I like to reference Netflix has this current mockumentary called American Vandal. I don't know if you've heard of it or if you've seen it, but there's a funny running joke in this particular mockumentary about the use of the word hey and whether you include one Y or two Ys. And apparently 2 Ys is flirtatious and 1 Y is normal. I had no idea. And my brother's a little younger than me, and I asked him, I said, I got to ask you, because I feel like an old person asking this, but is there a difference between hey and hey? And he goes, oh, absolutely. Just deadpan. So it goes to show you, I think when we think back to the early days of the internet, when you jump into an AOL chat room and people would just shorten things with ASL for age, sex, location, or maybe you just abbreviate LMK for let me know. Now we have a whole nother layer, as if emoji and shortening things wasn't confusing enough, is how do we punctuate our particular words, and think about how many folks may send the double hey Y, and the person on the other end thinks, oh, this person has a heavy finger. They just pushed Y twice versus they're actually trying to flirt with me. So as simple and black and white as text may look, it's getting more and more confusing by the day.
Yeah, I'm really glad I know that one so I don't end up accidentally flirting with my son, for example. I appreciate the tip on that. One of these tweets that's called out in the moment is a parent who received a text from their irritated daughter that just said K, but with a period, and was completely oblivious to the fact that she was connoting some sort of displeasure by including the period, and that the parent answered back, including periods in their text. And for the next several months, the daughter thought that the parent was mad at her because
See, this is back to our earlier point. Parenting is difficult, and this makes it more difficult.
Right. Exactly. Matt, any thoughts?
Pick up the phone. That's all I got.
No, absolutely. But
no,
go ahead.
One interesting tidbit is that intuitively, it seems like our language should be coming more together as the internet reduces the cost of transmitting ideas and information. But at least in the United States, our language actually since the 1960s or 70s, it's becoming more dispersed, and so our cultural idioms are less shared than they were. I mean, obviously, there's still a lot that's together, but that's something that's a little bit counterintuitive. That I would have thought that we would have been just speaking with more of the same language than we actually are.
Yeah, I mean, it does seem like things are becoming more and more splintered, and that all of this is going to wind up, some aspect of litigation in probably multiple jurisdictions, because all of trying to resolve our disputes is trying to determine what people's thoughts were and whether consent was obtained or what kind of a message they were trying to get across in writing, and that this is all going to be fascinating. So, Gabby, I hope you and Professor Goldman will develop either supplement to the emoji article or start launching off into how we are to interpret, or how courts are interpreting these kinds of signals.
You got it in caps, exclamation point.
Thank you. Thank you so much. All right. I think we're going to move on into our concluding material for the show, including an animal selfie of the week that is quite a stunning one. There is a gentleman whose name is Christian Moulek, and I'm not sure exactly where he lives. I believe it's in France, because I looked up his website, and the sort of experience that you're seeing here in this video, if you are watching with us, is one I think he does in the Auvergne region of France. And what Christian does is he rehabilitates orphan geese. and trains them, helps them get back in the air, and then helps them get back on their proper migratory paths. So he flies an ultralight aircraft, and that is the footage that we're seeing here, is up in the air with the geese who actually know him, and so will fly alongside with him as they are flying in flocks through the air. And it's just beautiful footage. And you can actually go up with him on his ultralight. There are 2 seats, and he puts, if you purchase a seat, you're the passenger, you're that person sitting in front, and you have this amazing experience of flying along with the geese in the air. And the reason it is our animal selfie of the week, for purposes of animal footage and who owns the copyright in animal footage, is that neither Christian nor the passenger appear to be the videographers, although I've seen a couple of passengers with helmets on where there are GoPros on top. As you can tell from that particular camera angle that we're seeing now, there's an arm that sticks off the ultralight with a camera that captures the experiences while you're flying. It looks like there are multiple perspectives on that. So it is sort of an automatically generated video of these animals in flight. And so we get to ponder who might own the copyright. I'm thinking with Christian setting up the cameras, etc., it's a pretty straightforward answer that he does, unless you're maybe one of the passengers paying. I looked it up on his site. It costs almost $800 to go up and take this journey. But gosh, I mean, once in a lifetime kind of magical experience. So that would be our animal selfie of the week. Other than anything you guys want to add, Gabby?
I'm so grateful they are taking videos, because I'd be too nervous to go up there myself. So I feel like I can experience by watching that. So thank you for that video.
Yes. All right. Our tip of the week is hilarious. It's kind of detailed. The actual tip is how not to do a DMCA takedown notice. Over at Plagiarism Today, Jonathan Bailey makes it even, a stronger indictment, calls this the worst false DMCA notice he's ever seen. It's this incredible saga that played out for someone who developed a video game and launched it on Steam and PS4. His name was Richard La Ruina. And he claims to be the world's top dating guru, and it's a game that is supposed to coach men in particular, into how to pick up women. So as part of promoting the game, Ruina's PR department handed out review keys to various reviewers on YouTube and elsewhere. And the folks were encouraged to check out the game and say what they thought. Well, one of those users was named Chris Hodgkinson. He has a review series entitled "Blank is the Worst Game Ever." So the PR department actually decided it would be a good idea to reach out to this person and see if they could get featured on their show. I don't know how this guy gets asked to review things with that kind of a series. And in fact, he's got a very, very small subscribership as these things go. He's got about 17,000 subscribers. He, as you would think, given the name of his show, gave the game a bad review. The game was called Super Seducer, by the way. Oh, my. So Super Seducer got a bad review. And the creator took it personally, took it badly, started commenting in the YouTube comments first, and then it all moved on to Twitter. And this sort of, I know you are, but what am I kind of exchange took place on Twitter, where it looked as though things had amicably resolved between the two, when the reviewer said, in all caps, by the way, Gabby, you sent a review code to someone who literally makes a series called "Blank is the Worst Game Ever." At which point the game developer, Richard La Ruina, had to come back and say, yeah, that actually is pretty dumb, isn't it? LOL. Sorry for talking bleep then. You were just doing your usual thing. And it might have ended right there, but it didn't, because somebody who thought it was wonderful that the game developer had decided to bury the hatchet and say, oh yeah, that was pretty dumb, and was applauding him for that, added to the discussion and said, wait, he admitted he was wrong and apologized instead of getting pissier and then filing a false DMCA takedown request, intending to give this guy backhanded praise and applause for not going the alternate route. At which point, Richard La Ruina said, oh yeah, I could have filed a DMCA request.
Oh my gosh.
If only he had known his options.
Thanks for the reminder. Yeah, he says, yeah, we have our DMCA subscription, whatever that may mean. He obviously subscribes to some service where he can just push a button and send a takedown request. I forgot about it. Nice one, dude.
I believe in freedom and democracy and that American stuff. What?
Yeah. Oh my gosh.
At which point I know you are, but what am I, went back into full force. The reviewer said, yeah, that's not something you want to do. And once again, the game developer, it could have ended right here, said, I decided not to. I believe in freedom and democracy and that American stuff. We only DMCA people who rip off our products. And at which point the reviewer just threw fuel on the fire and said that what this really meant was, I really want to, but know what happened with Digital Homicide and Cool Cat, who apparently were the subject of their own false DMCA claims and perhaps prevailed on them, as you can under Section 512. So the Super Seducer creator decided he was not going to be called out that way without responding. So he filed his DMCA takedown notice. After already saying, no, I'm not going to do that, and it was silly, and I know that this is not about copyright. He's basically admitted all that.
Oh, my goodness.
Yes.
I think I met this guy in high school.
Yeah. And then so the end of the story goes, the DMCA takedown notice, the wrongful one, the fraudulent one that you can get punished for and fined significantly for, was sent. And then the PR department, on behalf of Super Seducer, got involved and canceled it and sent an apology. What else? There was some money that changed hands. Super Seducer's creator, La Ruina, sent the reviewer $50 via PayPal. Just because. Not because it was
why not?
or anything, just, for fun. So back to our tip of the week. Don't use the DMCA this way. It will come back to bite you, haunt you, and make you a miserable individual. Anything to add, Gabby?
Oh, and also don't have those kinds of arguments online like that. This isn't the sandbox. I mean, it's laughable to see that was the back and forth too. So be very careful what you say in writing. The E in electronic anything stands for evidence.
Right. And remember the CFAA and RICO and wire fraud.
Always.
All the above. Any thoughts, Matt?
No, and don't name your company the Super Seducer.
Yeah.
Because don't.
Just don't. Say no.
Say no to super seducing. Okay, we've got a couple of great resources of the week here. An author named B.J. Mendelsohn reached out to me. He has a new book out called The End of Privacy. And interestingly enough, of course, you should run out and buy the book if you enjoy consuming books in that form. But he's also just podcasting the book chapter by chapter. So if you'd prefer to consume it that way, if you go to bjmendelsohn.com, and there's a longer link to the actual podcast, but that will be in our discussion points. Chapter 1 is up now, and some highlights from this chapter include taping over your webcam, which browser is the most secure, search engines allowing you to search without tracking your activity, all kinds of stuff that we talk about over and over again here on the show. So thought that this would be a great resource for our listeners. And also a great resource for our listeners is, of course, Hustle Over Entitlement, Gabby's podcast, which we've talked about a little bit at the top of the show. It is on hiatus until its second season. Gabby, tell us some of the highlights from season 1, if you would.
Oh my goodness. Well, obviously Denise's episode is one of my favorites. And the reason is, for those of you who don't know, Denise doesn't always tell her stories. So you get to hear how she arrived at her current role, and it's very inspiring. Some of my other favorites, we have a guest named Tamer, and that's actually his page right there. And Tamer used to work at a big tech company. He was, doing engineering work and decided, I love movies and I'm going to create movies that tell the stories of those whose stories haven't been told yet. And he has started launching some of his pieces now online. So we're very proud of our hustlers, as we call them. You can take a look at their bios on our website as a supplement to listening to their stories, streaming on everything from iTunes to Google Play to now on Spotify, and hopefully be inspired. And please do hustle. Don't hesitate to reach out to us at hustleoverentitlement@gmail.com. If you were really inspired by somebody and have questions, follow-ups, or you want to nominate someone. We're currently recording for season 2, and we're always looking to highlight people who are doing amazing things. So thank you so much, Denise, for giving us a shout out.
Thank you so much. Love the show, and love that you are helping inspire people everywhere by doing it. So you've certainly inspired us today by joining us here on This Week in Law. We can't thank you enough for coming back on the show.
Oh, I always love being here. It's like the best part of the week. So thank you so much.
Oh, that's great. Yeah, we loved having you. Wonderful conversations today. Good fun. Not terribly musical, except for the Fire Festival.
Yeah, even that was not so musical.
It was not very, very musical at all. No, but it was really, really fun, and loved chatting with you again, Gabby, as always.
Too.
Anything you want to leave our listeners and viewers with, as far as other than just checking out your podcast, what you're up to or what they might want to pay attention to until the next time you join us?
Oh, goodness. Well, unfortunately, there haven't been too many emoji developments. I will tell you, though, that I believe Eric's piece will be published in this calendar year. So I will share with you where that will be so people can check out the final product. But, we're always working on a couple items. So feel free to reach out to me. You can reach me online, ipwithgz.com. If you see something cool in the nonverbal legal space in another life, I was a social scientist. I did a lot of work in the nonverbal communication place. So I like to combine that with the law and technology. We can come up with some cool conversations and interesting ideas as we continue to parse through how to make sense of this communicative world we've created in this very heavy tech modern era. So thank you for having me.
Oh, you're so welcome. Matt, great to chat with you too. Hope school is going well and everything's going great with you these days.
Yeah, things are crazy, but that's the way I like them. We got spring break this week, so nice. No classes, and as everyone remembers, that doesn't actually mean that you don't have to study, but it'll be fun, and hopefully it'll start warming up here pretty soon.
Yes, hopefully so. You haven't been getting hit with the really bad storms like the East Coast has, have you?
No, we just keep getting played with like a 50-degree day, which is really exciting. And then like it goes back to like 12. So yeah, that kind of misery, but not the bad storm kind.
The really bad storm kind. Well, to enhance your break and your ability to get stuff done, and just for folks' future reference in their planning of enjoying the show, we are dark next week on March 16th. We will not have a live new episode of This Week in Law, but we'll be back on the 23rd of March. So mark your calendars for that. If anyone needs a break, you get one next week from TWiL. We do record the show every Friday, other than the ones that we don't, like next Friday, at 11 o'clock Pacific time, 1800 UTC. You can join us live if you go to twit.tv. At that time, you can jump in our IRC chat, which is always great fun. Love interacting with folks as they're watching the show. But don't worry about it if you can't join us live. Our entire archive of shows is made available for your viewing and listening pleasure at twit.tv/TWiL. This episode will be up there shortly, as are all of our past episodes going all the way back to the beginning of time. What else? You should write in and tell us what's on your mind about the show. If you have anything to add to what we've discussed, if you have other things that you would like to hear us discuss, please do get in touch with us. I am what am I? I'm Denise at twit.tv. And, Matt is Matt C at twit.tv. Mike Keys, who couldn't be here this week, is Mike at twit.tv. So reach out to us. Somebody reached out to me in the last week wondering why we haven't discussed FOSTA yet. I did have it in the rundown for today, but we all felt like we needed to really sit with this a little bit longer and get our heads around it. So we're going to do that. And teasing the next show a bit, we will definitely talk about SESTA and FOSTA and Section 230 and what this means, what this new sex trafficking law that was enacted in the United States means as far as censorship and the web. We'll get into that. And I've been wanting to get into, too, since there's been much discussion of FISA recently, and we have discussed FISA over the years and FISC, the FISA court. Wanted to talk about that a bit, too, and help people's understanding of that somewhat obscure and secretive procedure. And so we've got that stuff on deck for the next show. So do stay tuned for those things and let us know what else is on your mind as well. You can go on over to our Facebook page if you'd like, or what I like people to do and find really useful is whatever your information diet is and how you are taking in your news and seeing things that might be of interest to us here at the show, is just let us know on whatever platform that is. If you see it on Facebook, go drop a comment on our Facebook page. If you see it on Twitter, hit us up there. I'm D Howell on Twitter. Matt is Law Pint on Twitter, and Mike is J Michael Keys over there. So that's definitely helpful as well. Just makes it easy on you. And I love to just aggregate from all of those sources as we're getting ready for the show. So however you get in touch with us, please do so. It's very, very helpful. We love hearing from you. We love knowing what's on your minds. So please keep it up. One other way you can let us know what's on your mind is if you haven't taken the TWiT survey yet, please do that. Head on over to twit.tv/survey. You can weigh in on our show, all the other shows on the network. We definitely value your input, and that's a great way. We do this every year for you to give us some detailed thoughts about our programming here at the TWiT network. And also, if you are an Alexa user, oh gosh, the one thing we didn't talk about this week, maybe we can just do it right here at the bottom of the show as I'm wrapping things up. If you're right after I plug this, if you're an Amazon Echo user, you can enjoy the TWiT Flash briefing, which is available now in Canada, Australia, the United Kingdom, and India. It's been in the US for a while now. So if you haven't done so, go ahead into your Alexa app settings, and under Flash Briefing, you're going to look for TWiT, and you're just going to add us in there to your rotation. It's definitely a part of my morning. I did intend to call out, although it's only sort of tenuously related to legal considerations, the fact that everyone this week is up in arms about the fact that Amazon's Echo devices are laughing at them without provocation, and sometimes declining to carry out activities that they've been asked to do. I do think that there could be legal overtones to that if, various terms of service or other liability issues. Certainly, I'm sure people are emotionally disturbed when these devices start laughing at them. That could be a legal concern for Amazon. Gabby, have any of your devices been laughing at you this week or elsewhere?
To be honest, I don't have any of those said devices. I mean, that would terrify me. One of the accounts I read about, someone was trying to ask Alexa to turn the light off, and she just started cackling. I mean, as you're going to bed, that's an absolute nightmare. None have laughed at me. I haven't heard of any of my friends' Alexas laughing, but it makes you think about development too. Apparently, a big issue is when people said light. It sounded like laugh, which is why the cackle came out. So being very careful with our artificial intelligence, with our, voice recognition software, and just don't be creepy. Please don't be creepy.
It'll be implemented.
Definitely. No, I haven't. I'm the opposite of you. We have several of these things in the house. And one thing that I've done that I think mine haven't been laughing at me either, but I think it helps if you rename them, if they're not all named Alexa. So, I have different ones named different. Unfortunately, they should give you more options of what you can name them, because as far as I know, there's only 3 things you can call these devices. You can call them Alexa, you can call them Echo, or you can call them computer after the dialogue in Star Trek with the ship's computer. So, I like having them name different things in different part of the house. Mm-hmm. So that, obviously it can hear you from, you're talking to the right one if you say the right thing. It's kind of hard to keep them all straight. But I think that helps. And the creepy laughter thing. I don't know Amazon, but it's a known bug. They're definitely trying to fix it, or hopefully have fixed it by now. But that's one definitely to try and develop around. Matt, what about you?
No Alexa devices for me or any of those. But my sister does have one, and my nephew, who's 4 or 5, he always tries to tell Alexa what to do, and Alexa just will not listen to him. And it gets so frustrated that his sister, who's a year older, can get Alexa to play whatever song she wants, but Jack's voice just doesn't pick up on Alexa. No dice.
Yeah. So more, emotional damage being wreaked by the devices on your poor tender age. Did you say he's your nephew?
Yeah.
Yeah. All right, Amazon, you're on notice. Anyway, it's been a really, really fun show. Thank you both for joining us. Thanks to all of you for joining us today on This Week in Law. We will not see you next week, but we'll be back on the 23rd. And until then, take care.